Roland, gonna get to the math portion of our program here. I never promised there'd be no math, so you can't hold me to that. We have Bob Cochran from DHHS and Emily Maida from our team here at AOC gonna present North Carolina statistics.
Everyone hear me okay? I realize my throat's a little scratchy this morning. Where'd my coffee go? I'm trying to steal my coffee.
I know.
So hopefully so looking at the schedule, it didn't dawn on me. Emily and I are going to be talking about data right after lunch. Recipe. You guys make good planning?
Excellent.
Oh, okay. Anyway, hopefully you don't go into a food comatose as numbers are put up on the screen or what have you. But anyway, we want to follow up in many ways to what had already been talked about. Focus on some of the data we know or have about our people in North Carolina coming through our various systems. I'm going to focus a little bit on capacity to proceed, as we call it, not competency, but capacity to proceed here in North Carolina, with a little bit of extra focus on the misdemeanors that Judge Leifman has been talking about. So just as a quick summary, capacity evaluations are on the rise, and we're not alone in North Carolina. This is truly a nationwide crisis, as many have called it. The numbers are pretty staggering. Here in North Carolina, we're now at over 2,000 evaluations a year. That's initial capacity to proceed evaluations that are being conducted. And we'll talk a little bit more than half of those individuals are being found incapable to proceed. And I'll perhaps try to respond to Judge Leifman's question about why are the numbers so high here in North Carolina, and I don't know the answer, but I have some ideas. In North Carolina, until more recently here, we're trying to expand our restoration to other sites, but in North Carolina, the capacity, those found incapable to proceed get their capacity restoration only at the hospitals, which have, as we all know, very limited resources, very limited beds. So I'm not going to make you look at all these numbers, but I'm just going to highlight to prove my point or to show my point that even just 2 years ago, there were a little over 1,600 evaluations, and now we're at 2,100. So what is that? For those who are good at math, 25% increase, 20% increase in just a couple of years on the number of referrals for capacity evaluation. So our evaluators, our local evaluators, our evaluators at Central Regional Hospital have a lot on their plate. This year alone, and this is just capturing up to the end of August, actually. I just kind of wanted to see, well, where are we so far in 2023? And I think we're really on the same trajectory, probably 2,200 cases. Our local certified forensic evaluators, and I won't go into the system and how it works. I'll assume most of you know, but if you do have questions, feel free to interrupt. But our local evaluators do a good chunk or majority of the a little over half the evaluations, I should say. Mostly or many times misdemeanors. And then folks at Central Regional Hospital conduct about 800. I don't have the data for this year from them yet.
Well, I don't know where they do it.
So I'll start with the how long does it take to get those evaluations? Now, the statute actually says that depending on if it's a misdemeanor in custody, out of custody, which I lay down here, 10 days, 20 days, maybe you'll have 30 days or 60 days if they have to go to Central Regional. But the clock really starts from the evaluation. The statute says from the time of the evaluation, you have such and such number of days to complete the report. And by and large, the evaluators are doing a very good job of that. In fact, the median is only a couple of days. Now, the question should probably be from the time it was ordered, right? That's not what the statute says. But if you do look at the time it was ordered, the numbers are not bad nonetheless. It's 21 days on average and 12 days is the median. So, you know, by and large, they're getting them done within sort of the statutory expectations. So what happens then when they are evaluated? So they wait not too long to get the report. When they're evaluated, as you'll see here, 60, and these are just the raw numbers for, again, up to the end of August, but about 60% are being found ITP. And if you just take out the individuals who are charged with misdemeanors only, So obviously some folks charged with felonies and misdemeanors, but if you look at the misdemeanors only, close to 70% of them are being found incapable. Quite remarkable, and I'm very familiar with the national data you referenced, Judge Leifman. It's between 20 and 30% for initial evaluations, depending on the setting. And if it's an inpatient setting and jail setting, those numbers vary. But why is it so high here? And again, I don't have an answer, but I do know it's on the rise, not just in North Carolina. Speaking with colleagues in other states, the numbers of folks found incompetent or incapable are certainly going up. Now, some argue, or I've heard some argue that, well, the acuity level's going up. They're only referring to the more sick people.
Maybe, I mean,
Maybe that's it.
because even in our own system, the police have stopped arresting the moderate people that they can get into direct treatment. So, I mean, maybe indication of something good you're doing, not bad.
Potentially, but it's still fairly alarming. When I got in this
It's
position,
still too high.
yeah, when I got in this position just a little over a year ago, that was one of the first things I looked at was how often are we, finding them? And I was quite taken aback, to be honest, for the same reason. I was familiar with those national numbers. Yeah.
Is this just for individuals that are charged with crimes, this study?
No, these are individuals who have been charged with a crime in order to undergo a capacity evaluation.
Okay.
So the court has questioned the attorney's motion and the court has ordered an evaluation because of some concern they're not capable of receiving.
Okay.
All right, so now I've got a few different sets of numbers I'll highlight here. On the far left, these are the number of individuals who've now been found ITP. So we're talking about the folks found incapable, that fairly large percentage. How many have been on our wait list? And going back to August 22, we had 150 on the wait list. That number started to slowly rise, right? Reaching its peak around March of this year. And I like to think the trend, which is maybe starting to tickle, no, the peak was actually in June. The last few months has trickled down just a little bit. I don't know if that will hold or not, and nor do I know what to attribute it to, but those are the number of individuals who are awaiting restoration. Now, by comparison.
Are those
yeah.
all in jail or some of those outpatient?
Now, some would be outpatient, the overwhelming majority are jail.
Okay.
Now, by comparison, I just listed a few at the bottom.
Make you
Texas,
feel better.
it made me feel great. Now, no, no comparison to population size. We'll circulate that up. Now, Texas has a large number. They're a bigger state, of course. Georgia still has a lot, 360. Virginia's doing better. Oklahoma, 200. That's just an example, but it is nationwide. A lot of people, and that's where some of these civil suits, I think was brought up earlier, are coming from, is because they're not getting the treatment they've been ordered to get. They're waiting way too long to get that treatment.
And it's been adjudicated unconstitutional to do it.
Yeah.
Wait too long.
Yeah, in some states are forced to do it quicker and they're not able to do it nonetheless. So it's a problem. It's a true problem. Here are, how long does it take to get to one of these three hospitals that we have for restoration? I'll get into our pilots a little bit later, but I want to focus on the hospitals because that's where most of it's done. The average wait time is 250 days at Broughton, 266 at Cherry. Very long, what's that, 7-8 months, folks are waiting or more. On average, and then Central Regional is a lot less, but it's still close to 2 months. There is a lot of variability. I didn't put the standard deviations there, but and there's also variability across time. But nonetheless, that's what a snapshot is today. And here are how many patients just at the bottom they currently have. ITP patients again. So on this slide, I just wanted to highlight, and this wasn't my slide, but I borrowed it from other folks at DSOF. But it really highlights the trend over the years of how many beds were available to what is available now. Now, technically in 2023, you might not be able to see it, but this last indicator says there's 902 beds. Well, there are 902 beds, but guess what you need to run hospital beds or people in those beds? You need people, you need staff. And right now, we're only able to staff for 600 of those patients, right? So about a third of our hospitals are beds being underutilized or not utilized at all. To highlight again something that was mentioned earlier, ITP, those found incapable, are taking up an increasingly large percentage of these beds. So folks are getting stuck in the EDs. We were talking over lunch about how a lot of folks are in the emergency departments waiting to go to a hospital, but they can't get there because the hospitals are full, and they're full with a lot of these cases, these ITP cases. Close to 30% now represent the admissions. So they get to the hospital. How long do they stay then at the hospital? So these ITP patients arrive there. Again, I put the medians in the gray bar because I think that's a better representation because we have just so many outliers. Some people there for years and the cases are unique. But nonetheless, it's a long and variable wait time. Now, NC Rise, I'll mention our pilot now, is our first capacity restoration pilot outside of a state hospital, and it's located in the Mecklenburg County Detention Center. NC Rise stands for North Carolina Recovering Individuals Safely and Effectively, and it's run by the contractor WellPath. They are seeing patients. They have a 10-bed pod there, people who are waiting to go to the hospital, right? People who are still slated to get the restoration to the hospital, but they're basically starting restoration right there in the jail, right? They're letting the courts know, the attorneys know, but they're proceeding to treat those individuals who are able, not like the most sick individuals will still need to go to the hospital, but a large chunk of them can get treatment, don't even need to go to the hospital. And I won't go on a tangent, but a really pet peeve of mine is a lot of these folks are slated to get restoration in the hospital, and they don't meet IVC criteria, which they technically are supposed to. But they nonetheless have to go there or do go there. But NC Rise is able to restore, and it's a little bit of an unfair comparison, I get it, because they're not as sick, but nonetheless, they're able to restore and get these people back to court, get their cases resolved, and never end up having to go to the hospital, freeing up hospital beds and shortening those wait times. So we're looking to expand those. We have 2 more in the works in Wake and Cumberland, and we also have 3 community ones, but I won't probably say much more about that unless anyone has questions. All right, just financial costs real quick. Not that I probably need to tell anybody, but you put someone or give someone restoration outside of a hospital, you just rack up the money that is being saved. The day, month, and annual cost per individual is about 1/4 less if you put them, for example, in a jail-based program versus a state hospital. There are other costs, though, not just money. It's not just all about money. It's about the care that these folks don't always get. They don't always get it in a timely manner, right? They're sitting in jail, not getting treatment. Jails, unfortunately, don't have a lot of resources. So many of these people languish in their psychotic illnesses, like Judge Lightfoot was discussing, not getting the treatment that they need. And many of them aren't getting it at the right level. We have, for example, intellectually disabled individuals found incapable. They do not need to go to the state psychiatric hospital. In fact, it's the worst place for them. But nonetheless, we're not matching the right level of care necessarily to what the patient needs or the defendant needs. And the system gets overwhelmed, and there's lots of course, consequences there, court backlogs, and so on. Now, DHHS and my friends and colleagues, Tracy, Stella, who do fantastic work in that division, have a lot of different programs that have launched. Some are, I guess we're calling deflection versus diversion. The CIT sorts of things are going on. And other types of diversion programs. The number in the brackets is how many programs there are. We have 7 mental health courts in North Carolina, quite variable in terms of how they operate and how effective they are. But nonetheless, I just wanted to highlight some of our efforts that are going on now. Oh, and I will expand about our capacity restoration pilots. They are in 3 counties right now. Mecklenburg, Wake, and Cumberland have the capacity restoration on a community basis. As I mentioned, Mecklenburg has the jail program, and Wake and Cumberland detention we're getting on board, hopefully by the beginning of the year. And maybe after today's discussion, we'll get some momentum and consensus and maybe have some type of post-arrest misdemeanor diversion. I would really love to see that come to fruition here in North Carolina. I think it would help our capacity. It would help just in a number of ways. So speaking of the misdemeanors, what happens to these folks? Well, some go to the hospital. A lot of them don't, though, right? They time out, right? They are sitting in the jail. They're waiting on that bed. The case gets dismissed because they served with most, period of time in custody they could have anyway. We get some that go to the pilots, of course, but oftentimes they leave the jail and they don't have the services they need. They're just not connected. Again, the jails quite often, sadly, don't have a lot of resources. They don't have liaisons in many cases to connect them to community services, and the community services are lacking. So this is just this revolving door and recidivism that we've all become more and more aware of. So I'm envious of Florida. When I heard you talking about all the great data you have, we have data, but we have a ways to go. And I was really excited, once I got to know Emily and we got talking and about how we can start working together to sort of work on some better data collection. Because we don't know a lot about the high-risk folks. The folks, what'd you call high users? Yeah, high users. We don't know a lot about that population. How often do they recidivate? Where do they go? Do they go to the hospitals? Do they go to other programs? So we really need more data on that, I believe, moving forward. We also are not sure, at least I'm not sure, about which cases are getting dismissed and how long, are they in custody when they do get dismissed. So I think some more data could really help us understand what's going on so that we can make better decisions. We're also seeing, although Justice Newby's not in the room right now, but he referred to, and I was encouraged by this, that the calendaring of cases is improving, or at least in some jurisdictions. But that too is another sort of part of this system, and I say system in the broadest sense, hospital, jail, courts, and so on. We're all interconnected, but a lot of times these cases, they don't get calendared, very quickly, these mental health cases. And these folks end up sitting in the jail longer, even after they've been restored in the hospitals, right? And guess what happens when you wait a long time with a mentally ill person? They decompensate, and then they get another order for capacity, evaluation, and then restoration. It just starts all over again. It's really sad and unfortunate. So the AOC and I, we've been talking, DHHS and AOC have been talking about a data sharing agreement, so we can sort of work together at understanding this problem better, so that we can make decisions about further programming and whatnot moving ahead. I should mention also, we've gotten a lot of technical assistance from Samson's Gaines Center. They've been fantastic, not only with the capacity restoration, but even helping us with our data collection efforts towards other programs such as post-arrest misdemeanor diversion. And I'll just sum it up here before turning it over to Emily. But I really believe that some type of diversion program, post-arrest diversion programs, would really supplement the many other things that we are doing. It could really have a huge impact. It would allow capacity evaluations, and restorations could be reserved for certain cases, not all these low-level misdemeanors, for example, and really streamline things considerably. And it also would allow them to be better engaged with mental health and behavioral health services by having an alternative like that. So with that said, Emily, I'll turn it over to you. Unless there were questions that you want to field to me that, yeah.
In the 3 counties you mentioned that have these programs in the jails, who pays for the personnel and the equipment to operate and provide that service in the jail? Is it the county or the state?
Good question. It was from the governor's task force funding that we received for the jail-based restoration programs, and the community-based programs were all through a federal mental health block grant. So we are looking for sustained recurrent funding for each of these programs. And I believe we're going to be able to show, as the Mecklenburg program is already showing, I didn't put up all their data, but some pretty impressive results are coming out of there. And I think we're going to be able to show that expansion is warranted in other counties. And we've talked about maybe having regional, because not every county is large, right? Or or it would make sense to put a team of professionals in a jail for a limited number of ITP cases. But what if we shared resources, have a detention center hub that serves several counties, right? Or had traveling capacity. We're talking about traveling capacity restoration and other options to make it work, not just in the big counties, like the 3 I mentioned. Yeah, Tracy.
Maybe mention, Bob, the payment mechanism.
The what?
The payment mechanism for the vendor that pays back to the sheriff's department.
Oh, sure. So with the jail-based program like NC Rise, through the contract we have with WellPath, we pay them a certain, dollar amount per, individual that they serve. But of that, they are paying a certain cut, so to speak, to the jail for operational costs that the jail has as well. So the jails, they're gonna have to keep these people in custody and take care of them anyway, right? But they're getting an added little bonus because we recognize that, by putting people on a certain unit, by having, an operation shift slightly, that there will be some additional costs, so they get reimbursed.
One other question, and I'll not ask any further, but what's the analysis that shows for these nonviolent misdemeanors that it's better to provide them mental health services in a jail versus in a medical facility? That just seems kind of.
You mean for ITPs or?
Yeah.
So if I understand your question,
What we're trying to do, it sounds like, is turn the jails into hospitals.
Oh,
mental
I
health
see what you're saying.
facilities.
No, we certainly aren't doing that.
Seems like we ought to have a mental health facility if
Yeah.
somebody has a mental health problem. And I was just asking what analysis has been done as to why we ought to be providing mental health services in the jail versus in a mental health facility.
Okay, well, I think I can answer it this way. I like to think of it as different levels of care that people need, right? There are some people who need inpatient acute psychiatric care in a hospital, no question about it. Floridly psychotic people and so on. There are some people who can be safely placed in the community, right? They make bond, they would make it anyway if they didn't have a mental illness, right? Nonviolent types of things. And they need restoration. They have an illness, they have intellectual disability, whatever. So let's provide that, not in a hospital. Don't put them on the wait list to go to the hospital. Put them in the community. That's the level of care they need. However, there's this third group that doesn't need a hospital per se, but they're not bonding out. You can't, it's a violent offense, let's say. They're not going to make bond. Well, what do you do with these folks? Do you keep them in the jail and just wait on that hospital bed and put them somewhere they don't really need it? Or do you provide some more intensive care? It's not a hospital and a jail, but for example, in the Mecklenburg program, sorry,
No, not
your time, I realize. In the Mecklenburg program, we have, 5 staff members. There's, a part-time psychiatrist, a nurse, a program director, and psychologists and clinicians that we provide, or that WellPath is providing them in the jail for these ITP patients on a specific unit, that's devoted just to those folks. So I don't know if that really answers your question, but I believe we need different levels of care based on the need. And jails are not the new hospitals, nor should they be, but not everybody needs a hospital and not everybody bonds out.
That is a critique, though. I mean, your point is there is a considerable critique of jail-based capacity restoration on that point. A lot of people think.
It's debatable. Oh, yeah. And I've debated with some colleagues who are for and against it. I'm a believer, so if we can debate it and discuss the pros and cons, I'm happy to do that. But I perfectly recognize that there's good arguments for not doing it.
The other unintended consequence is that because of Medicaid policy, people who stay in jail lose their Medicaid, or it's suspended, so you're so folks who are gonna reentry don't have Medicaid, so they don't have any purchasing power for the treatment they need, so that's another consequence of the wait in jail.
The other just practical factor is Mecklenburg and Wake have new jails and large jails, and I'm not sure about Cumberland, but that's the exception rather than the rule across the
Yeah.
state.
And that's why I think we need to look at some alternatives, like talk about a traveling team that goes to the jail and coordinates, there. Or having a hub, a larger jail that maybe serves many counties and agreements between the sheriffs that the ITP patients will be sent to or defendants will be sent to that. We're looking at different models, recognizing that, not everywhere is Cumberland, Wake, and Mecklenburg.
I would ask y'all to maybe even think of a different alternative. Instead of focusing even on ITP for that population, look at diverting them out entirely into some kind of crisis care for stabilization, and then put a community plan together, and then you can use your mental health courts to monitor them. They get the Medicaid when they get out, they get treatment, not restoration. A lot of people get confused about restoration. It's not a treatment system. It's a way to get people restored so they can meet a legal criteria. And so to me, it might be more effective or think about being more effective to focus more on their treatment needs as opposed to their competency needs.
Yeah, no, I couldn't agree more. And that's why I think we need those kind of
Yeah.
programs to supplement, to focus on those we do need to do capacity restoration with and get these other folks diverted to the alternative system. Yeah.
What kind of staff does the Mecklenburg County Sheriff devote to this program that's in?
So they are hired by WellPath. WellPath is a contractor who is providing the service. And like I said, there's like 5 staff members. There's 1 officer that is devoted to that unit, to monitor and security and so on. But again, they would need to be monitored anyway, right? Just maybe not in that way. But it's not the staff, the Mecklenburg did not have to hire any staff. It's none of their staff. It's clinical staff, contracting, yep.
So are the evaluations being done via the web
Which evaluations do you mean?
for the ITP, for the people that are
In the jail?
yeah?
So once they get the restoration, they have someone on staff, a psychologist on staff who does the reassessments, just like a local evaluator would,
So in
or
person?
CRH would, in person. Yep, those are in-person
I was
evaluations.
just wondering what the difference would be, because like North Carolina is so higher than these other states, but I know like in Onslow County, a lot of the individuals, if they're incarcerated, they're being evaluated by a mental health doctor through video.
And that still does happen, especially for the initial
So
evaluation.
what would be how easy would it be to commit somebody? Have you seen a difference in a percentage of someone being committed via telecom or versus in person?
I'm not aware of that data.
Yeah, so there have been studies, excuse me, done of exactly that. Competency restoration evaluations, virtual versus in person, there's no appreciable difference. It's something we absolutely recommend, particularly in rural states, because it's a great way to keep folks from having to travel, the evaluators from traveling. And evaluation, there's not much difference. Sorry to get into it, Bob, but I will say that restoration, there is a difference. One of the things that we talked about as a recommendation is that just exactly what the judge just said, restoration services we would hope would be more treatment oriented and integration to the community oriented versus, can you answer the 2 questions in front of the judge that let us resume prosecution? And so that's why the CCJ Costco Task Force chief came out pretty strongly against jail restoration as a model. And the one other thing, let me say about jail restoration, I was a little surprised when that came up and it says, ooh, the RISE program. And I said, gosh, that sounds familiar because I'm working almost full time in Colorado right now on their competency program. And it's the same provider doing the same RISE program in Colorado.
There are several companies that do it in about 18 states.
Yeah, and I'd encourage you to look at the overall, when you say this, the outcomes are good. Are they restored legally? Sure. Is there any chance that they're getting any treatment benefit when that treatment is provided in a jail? And I think the research that's been done on that is pretty skeptical.
Well, again, we might be comparing apples and oranges. If you look at the type of restaurant, you're right, just answering 2 questions is silly. But if you look at the type of services they're getting, like in the NC-RIDE program, it's almost exactly what they get in the hospital. Same staff, different environment. They have a psychiatrist, they have a psychologist, they have, social workers and counselors. So I guess I would push back a little bit and say, what is that jail-based programs that you're talking about in these other
Sure,
places?
but that's kind of why I tied it into the question here is because the research with which I am familiar suggests that you can't really do therapeutic interventions very well in a jail setting because of the noise, because of the
I
incarcerated
see what you're saying.
rate. All of those things
Well,
suggest.
it's less than ideal. It's less than ideal for sure. But can you provide, what do you do with the individuals when they're in that setting already though, and they can't be released to the community? They're violent offenders, for example, who need restoration. But they have an intellectual disability and traumatic brain injury.
That's different.
Well,
What
if
are
they're
they gonna do at
IDD,
the
you're not
hospital?
gonna restore them anyway, right?
Well, no, it depends. I mean, it depends how severe the, injury is. I mean, we go on and on, but,
Anyway.
I guess, it depends on what that service is. Yes, it's in a jail setting, but again, Mecklenburg's a great example. They created their own unit, made it more therapeutic. I'm not saying jail is a great place for where we should focus all of our treatment. I'm just saying it's a necessary option for certain.
Absolutely, and especially given your increasing rate tax. We just both thought we ought to speak up to be sure and consistent with what the doctor said as well, that there is a substantial body of sort of resisting doing that for restoration.
True. And with that, though, there's also a growing number of states who are adopting it.
Yeah, because it's cheaper. Mine just
Yeah,
did.
And the
because
federal
it's
government- the federal government just started it too. And I'm not saying, again, I'm not saying that means it's the right thing to do or always a good thing.
But I'd like to offer a different perspective to you on our conversations around restoration and treatment. Capacity restoration is not a mental health intervention.
Right.
It's a function of our justice, and it's a very important one. But the therapeutic environment is back out in the community. And so regardless of whether that's happening in a hospital, which not all hospitals are good therapeutic environments, depending on the needs of the person. So there's worthwhile debate, I think, to have by really thinking about what are we trying to do? So there's restoration, and then what happens after the restoration, whether that happens in a hospital or a jail, we need a really strong community response.
Right. Transition is as important as whatever happens at the
Yeah,
front.
and I
Absolutely.
couldn't agree more. Whether they're getting their cases dismissed and leaving jail before restoration finishes, or they're in the state hospital, it's that transition to the community. Because I think both are valuable goals. Restoration in and of itself is valuable. But treatment and connection to the community is even more so, yeah. Great discussion. I don't want to take up too much more of our time on this section, so let me hand it off to Emily.
Thank you very much. I realize I'm over time, so I'll do my best to to make up some of the lost ground. No, not at all. It's a great conversation. My name is Emily Maida. I work at Research Policy and Planning here at the AOC under Director Boyce. I'm joined by my colleagues in the back, Megan Pittman and Juliana Kirshner. When Lori first asked me to speak on this issue and talk about what court data we have that sheds some light on the layers of this issue, I kind of got nervous because the answer is nothing. There's nothing native to our court data that would indicate to me any of the behavioral health issues that a person is facing. And so I think that really underscores the importance of this conversation, the importance of these multidisciplinary task forces. And without Bob, my presentation would be even shorter. I reached out to Bob and he saved me and essentially gave me and my team a sample data set of only 25 cases where the defendant was found ITP. And I really want to kind of hammer that point home that not only is this a sample, but this is a very, very small sample. So I would really hazard against trying to kind of extrapolate some of the issues that we uncovered here and project that out onto the entire population. That's really what we're hoping and aiming for with this data sharing agreement, is that we can look much more broadly and in a much more comprehensive and holistic manner. So 25 cases is what we started out with. There was one juvenile in the sample, so we excluded it from our analysis. And this is just some summary statistics about kind of the sex, age, and race breakdown using the publicly available identifying information. So no PII, nothing like that was shared. My team did a manual look at the criminal history of the unique individuals that were in the sample. And I think that's important to note, as Judge Leifman mentioned, this is not a recidivism analysis. This is literally just what is the criminal behavior of this population? What do we know about them? What types of charges are they engaging in? How frequently do we see their contact with the criminal justice system? And I think the outcomes of just very small analysis are really, really important and very enlightening. So we looked at the total number of offenses that were charged against these individuals, and then also the unique charges. So the difference between offenses and charges is the number of offenses is going to include multiples of the same charge. Across those 24 individuals, we found 775 charges for them in our adult criminal justice system database. Total unique charges that excludes multiple offenses is 151. And what that kind of amounts to is that this is already, by the time we know about them, or by the time DHHS knows about them and has been asked to perform an evaluation on them, they are cycling in and out. On average, the offenses per defendant, 32. The minimum was 1, where they were ordered for an evaluation the very first time that they were charged with something. The maximum was 143. And we'll talk about that defendant a little bit later on. And then the unique charges, 15 on average, minimum of 1, maximum of 38 different charges for the defendants in the sample. So what is the composition of those charges? And the results here are really consistent with kind of a lot of the anecdotal information that our North Carolina partners are bringing to the conversation, and also some of the harder data that Judge Leifman has shared with us. Which is that by far, 34%, the largest portion of all of the charges in our sample are nonviolent misdemeanors. They're also, the second most commonly charged is nonviolent felonies. And here in North Carolina, a lot of those are going to be your drug felonies of higher amounts of a substance. And then this third category is a category that we use sometimes when we're classifying charges in convictions. It's public order. It's a misdemeanor category. And what these are resisting public officer, first and second degree trespass, as we talked about earlier today. So there's charges like that in this category, but then there's also intoxicated and disruptive, disorderly conduct, truancy, obstructing justice. So 50% of this population is engaging in these lower level misdemeanors, right? These are nonviolent misdemeanors and public order misdemeanors. Only 11%, as Judge Leifman mentioned, did we find had been charged with a violent felony, and only 8% with a violent misdemeanor. So this, at least in our sample, would indicate that this is a nonviolent population. So here's kind of a separate way to look at, a different way to look at the earlier slide, which is just the unique charges by type and by defendant. So on average in the sample, the number one most common charge category, on average, the defendants in the population, a defendant in the population would have been charged with 5 nonviolent misdemeanors. The second, 3.8 for nonviolent felonies, and then the third would be 3.5, 3.4 public order misdemeanors. So what happens to these? What happens to these defendants? What happens to these cases that they're involved in? Well, I think, we've heard it mentioned anecdotally here today. It's also borne out by our data. The vast majority of these charges are dismissed. But the ones that do end in conviction, what happens to them? This slide here comes from the North Carolina Sentencing and Policy Advisory Commission. Their offices are just right on the other side of this wall. And they looked at misdemeanor conviction outcomes across these different charge categories. Your person-based offenses, those are going to be your violent misdemeanors, right? But the property, drug, public order, and traffic are your non-violent misdemeanor categories. And what this indicates is that somewhere between 73 to 81%, depending on what the charge is, they are sentenced to active time that is equal to their time served. So even in instances of conviction, these people are just getting released from jail to just cycle right back into the system again. So this one, this defendant is a particularly interesting gentleman, but as Juliana, my colleague, described it, as we were looking at his charges, you could literally see this man's life play out. Again, this is just adult criminal justice system data. So it would have started when he was a teen. The age of criminal responsibility was going to be 16. So the first time that we see him, that we know of him, is for reckless driving at the age of 18. In his 20s, he has tens, like over 50 instances of worthless check and obtaining property by false pretenses, misdemeanor charges. Many of them were dismissed. They're from places like Pizza City, Walmart, grocery stores. He does have an assault on a female in his 20s as well. Between his 20s and early 30s, he's in and out of DPS and community corrections custody for his prior obtaining property by false pretenses convictions and then probation violations. At this time, though, we really don't know where he is. And that's kind of a hole in our data that if we had this data sharing agreement, we could determine if he was receiving some sort of mental health treatment or in a hospital somewhere, because we don't really know anything else about him in his early 30s. We see no new offenses and we don't know where he is. He comes back on our radar in his mid 30s. And he's graduated from these low-level misdemeanors to B&E, forgery. There are 4 instances of charges of statutory rape. Those 4 rape charges were dismissed, but he was convicted of indecent liberties. He's in jail. He is charged with a misdemeanor escape jail. He ultimately gets convicted, as I mentioned, on the indecent liberties. He's incarcerated for that from the end of 2013 till May 2022. We don't see any new charges while he's in DPS custody at that point. He gets out, and the first thing that he does that we see him do is fail to register as a sex offender. That is the case that that Bob gave to us and said that this defendant was ordered to receive this evaluation on the failure to register as a sex offender. We now know that he currently has pending charges for indecent liberties and communicating threats that occurred after this failure to register as a sex offender. So that kind of gives you the life trajectory of just one individual in this sample. And I think
Sorry, could you tell us where he is in terms of his ITP process now, or?
I don't know. You?
No, where it left off was I provided Emily individuals who were evaluated and then found incapable.
Okay.
They hadn't got to the hospital yet necessarily, so I presume
He's somewhere in between
jail.
right now, somewhere probably.
And is there a way to know if he was like a foster care kid?
Well, I'm sure somewhere, some place has that data. I'm gonna talk about, some of the limits in our data and how we have so many different sources and how do you coordinate that? But I certainly don't know, and I'm not even sure where to look, but I'm sure someone here might be able to know. We make a connection with the county he's from, their local foster care system, probably has a registry, I don't know.
So I think that and this is my final slide, I think it, again, especially Mr. 143's life kind of, again, underscores the importance of these types of conversations, because there really isn't an opportunity, especially in his life, for early identification, right? And the sample also bores that out. So for folks in the sample, ages 19 to 29 years old, the average number of offenses was 11 unique charges. 30 to 39 years old, that increases to 28 offenses, 14 unique charges. 40 to 49, now this is being skewed by Mr. 143 because he's 47 currently. An average of 60 offenses and 23 unique charges. There were only a handful, maybe 2 or 3 defendants in the sample who were above age 50. And they had very few charges. Many of them were identified kind of on their first contact or known contact with the criminal justice system, average of 9 offenses and 5 unique charges. So that's all I have to share. We're very, very excited about the possibility of getting better optics into the overlap between folks that we see in our justice system and then what their behavioral and mental health overlap looks like. So thank you all very much for having me.
Thanks, Emily and Bob. Any other questions? Thank you all very much. Next, we have Lisa Coltrane. Lisa's a resource prosecutor with the Conference of DAs, and she's going to provide a DA perspective.
Thank you.
Thanks, Lisa.
I'm gonna switch this PowerPoint over. Can I get it I know we are basically past my time at this point, but while Lori is switching this over, as he said, my name is Lisa Coltrane. I am the Homicide and Arson Resource Prosecutor for the Conference of DAs. And that title doesn't immediately call to the fact why I'd be here. But I got involved in this and I became the point person for the conference because I was an assistant district attorney for 16 years out in the field. And as an assistant district attorney, I was in a rural county. I was always in rural counties that were underfunded. And, you know, from the time that you become an ADA until the time that you're prosecuting murders, you're dealing with people who are ITP. Thank you. Because you've got people who are trespassing and you've got people who are murders, and they're, you know, ITP runs that whole gamut. And so every prosecutor in the state is dealing with this issue. And so when Lori asked me to talk about this, she wanted to talk about some of the problems that we are seeing in court, some of the where the road meets the rubber issues that we're seeing. And when I was in court regularly as an ADA, I never felt like I fully understood what was going on. I felt like this process is very confusing. We've got this criminal justice system and this mental health system. I don't know what the mental health system is doing. And I felt like every time I had to do it, I was reinventing the wheel. I didn't feel like I was accomplishing anything when I actually would have people often evaluated. And so when I came on with the conference 3 years ago, I said, you know what, if I can't simplify this process, I'm at least going to try to help the prosecutors understand what's supposed to be happening. And so it started with a webinar where we were trying to explain the process, and I got some people involved in the mental health realm to help me out with that. And then it has expanded, and now we have semi-annual trainings to talk about these very kinds of issues and to bring these two organizations together that have to work together. And so the first of the concerns that I am seeing that from either prosecutors calling me or from my own experience or from the conversations that I'm having at the trainings that we have. The first of the concerns is with the local forensic evaluations. And I have some opinions about why our numbers are so high for people being declared ITP. So the process is that if there is a misdemeanor, there's no option for them to go to Central Regional to get an evaluation. They have to get an evaluation for ITP at a local forensic evaluator. And so here, the judge has to order a local evaluation if he or she feels that there's even an evaluation necessary at all. They have to order this local evaluation. There's no option for somebody that's charged with a misdemeanor. And the misdemeanor could be from a trespass all the way up to a DWI or an assault inflicting serious injury. And then additionally, even for felonies, the default is a local evaluation. The judges have an ability, if they feel it's necessary, to send the evaluations off to Central Regional, but the default is going to be as a local evaluation. Now, the concern here is that these local evaluations we are getting are not adequate. Anecdotally, when I was in the field and I was dealing with local evaluations, my local evaluations sometimes were 2 paragraphs. I was sending people out to be evaluated, and these local evaluations we were getting back were 2 paragraphs, as opposed to the ones we were getting from Central Regional that were 10+ pages. The local evaluators get 6 hours of training. That's the training that they get, whether it is, you know, and that encompasses testifying, what they're supposed to be looking at for the evaluations, what their report should say, and everything that encompasses that. And these are not people who necessarily have any experience in forensic mental health evaluations. They could be marriage counselors, they could be social workers, it could be anything, and they have a very limited amount of background and limited amount of education in these areas. And if we were getting adequate reports, it probably wouldn't be an issue. But as I stated, sometimes we're getting very, very limited evaluations. And in my experience, and I think that this is why we're having these high levels of reports of ITP, is because these local evaluators are going, well, seems like something's wrong. Let's just check the block and say they're ITP. By way of example, I recently was dealing with a case where person was charged with DWI. They were found to be ITP. the report goes back, the local evaluation comes back, says they're ITP, it goes to court, the ADA sees, oh, this person's ITP, dismisses the charge. And services stop at that point, nothing happens. Just a couple of months later, this same individual gets another DWI, but this time he crashes into a mother and her 2 children. At that point, for a reason that doesn't need to be discussed, it transfers to the Conference of DAs. So I'm looking at it, and I've got a little bit more experience than the average prosecutor. And I start looking at it along with another resource prosecutor, and we're like, wait a minute, he's evaluated again, and this evaluation says he's ITP, but the evaluator in that evaluation said, this defendant became upset and I just stopped the evaluation. I didn't go forward with the evaluation because he became upset, and therefore I'm ruling him to be ITP and non-restorable, in which there had been no efforts made at restoration, and there's really not any method to do any restoration for misdemeanors. And so we're getting these evaluations back, and to some extent, prosecutors who are in the field, these are state certified local evaluators. These basically have a stamp seal of approval saying this person's not capable to proceed to trial. And the prosecutors feel like, well, how do I go up against this? We certainly have the capability to challenge this in court. And in that case that I was just talking about, we felt like we needed to challenge that in court. We went to court because we have body cam footage where this same person who became upset was arguing with the officer about his Miranda rights, was challenging a post-incident to arrest search of his car, was agreeing to a consent draw of his blood because he knew that Chapter 20 was going to allow for a search warrant. We were like, we feel like this person is capable to proceed to trial, even though that local evaluator said, no, this person's not. Thankfully, a district court judge agreed with us and said, yes, this person is more than capable of going forward in court. And so the case went forward. But these local evaluations, this is the first concern that I'm seeing. I don't have an answer for this because I understand there are just not enough people at Central Regional to be doing these evaluations. They just don't. I don't have the answer, but I know that what is there right now is a problem. The second concern that we have, and this is kind of what we've been getting at this whole time, is that once an individual has been determined to be ITP, there just are not enough or sometimes any safeguards in place to prevent that person from reoffending. Because what happens is once somebody is found to be ITP, then the next thing that has to happen is that a judge has to determine whether or not that person is a danger to himself or herself and needs to be involuntarily committed. And once that happens, if they're not a danger and they're ITP, then they're just released. They're just put back out because they're not a danger, because they're doing something like trespassing or they're doing something like larceny, and they're just being put back out into the community with no pathway to restoration and nothing to put in place to help them with the underlying issues that may have led them to committing the crimes in the first place. And so it's almost like we're hoping this lightning bolt is going to come down, strike them in the head and give them capacity, because there's just the methodology for them to get to a place of restoration or a place of help with their underlying issues to keep them from reoffending. And so what we have is this revolving door. I've worked in multiple counties in this state, and just about in every single county, we have this issue where everybody in the justice system knows that this person is ITP. And they go out to this gas station that they have been banned from 100 times, and they go back there and they start panhandling. The businesses don't want them there. The customers don't want them there. So the business calls the police because they don't have any way to deal with this. The police get there, and most police officers will try to guide them away. But if they won't be guided away, or they become combative with the officers, there's nothing on that officer's duty belt that's going to help that situation. And so they pull out handcuffs. And then this person goes to jail, and they're processed through the magistrate's office and through the jail. And then they get to court, and the judge goes, Mr. Smith, I know you're ITP. We've declared you ITP 100 times before. You can't go back to that store. And the prosecutor dismisses the case. And
24 hours later, he's back.
exactly, they're right back out there within a week. And so we have these people where they are in court every single week, and we don't have anything in the courtroom to put a stopper in this. We just don't have anything in place right now to assist with this. And in addition to what happens to those people, the framework that we have right now, these charges are just out there lingering. Because if somebody is found to be ITP, once that ITP designation is over their head, we don't really do anything with that, except if they are potentially restorable, we just put them back out there, and the charges just linger. They just linger for 5 years if for a misdemeanor, or 10 years for a felony, and the charges are just out there causing, issues with that person, issues with the backlog, or what it looks like a backlog, because they don't have any way to get capacity restored. And if they're in jail and nobody has deemed them to be non-restorable, then they stay in jail. And sometimes these are felonies. And so sometimes people are spending significant amounts of time in jail when they've been deemed to be ITP, but we don't have a way to restore capacity. Because the only people that we really can hope to assist or hope to get hands on at this point are these people who are ITP, plus they are a danger to themselves or others, and they are have committed a violent crime. If those three things come together, then we can send them to the state hospital. But if one of those things is missing, then they're just out there, and these charges are just out there lingering. And so without having anything on our proverbial duty belts to help with this either, we just are setting these people in this revolving door, and we're making more victims out there when they're out there potentially committing crimes, because we don't have anything to either help them with capacity restoration or to help them with their underlying issues. The last issue that I wanted to talk about, and this goes a little bit beyond what we are talking about today, but frankly, it's the concern that I get, that I think is the most serious concern that I get from district attorneys and prosecutors who are dealing with these people, are the people who are ITP and they are non-restorable. Because we know that 15A 1008 tells us that once these two things come together, the court shall dismiss the charge. And so we have somebody who is ITP and they're non-restorable. The court has no option other than to dismiss the charge. And we understand why. We can't just have people lingering out there who are non-restorable. They're never going to be able to deal with their case because of traumatic brain injury or dementia or something that's just not going to be able to be fixed. And so we can't just, throw them in a hospital and throw away the proverbial key. However, when that happens, when this charge is dismissed, at that point, prosecutors lose all agency, victims lose all agency in the case, because what's holding them at that point is a civil commitment. And I've had multiple district attorneys who have called me and said, this person committed a murder or murders or homicide or homicides, and they're ITP. We get it. They're ITP, and they're not going to get better. And we sent them off to the hospital, and the case gets dismissed. And that's a difficult conversation to have with a victim or a victim's family, to go, we're sorry, but there's absolutely nothing that we can do about this. The statutes tell us that we have to dismiss this case. And we know that Jackson v. Indiana says we have to dismiss these cases, so these people aren't just languishing in hospitals. However, the fear and frankly has happened in multiple times that I have been called about this issue, is that these people are getting sent to the hospital, they get them on their medications, they get them regulated, and they get them stabilized. And at that point, they're no longer a danger to themselves or others. And so I have DAs calling me and saying, hey, this person just committed a murder 3 or 4 years ago, and now they're being released back out in the community because the doctors, we don't have any say-so. We've lost all agency, and these people are getting released back into the community. How am I supposed to be calling this victim's family and telling them this person's gonna be walking around Piggly Wiggly in a few days? And it's a real concern that the elected district attorneys and the conference district attorneys has. There are some models, I believe, in California and I think maybe Oregon of where the prosecutors and the victims who do have victims' rights under our Constitution do get some say-so in that because they just don't have any right now. I tried to make this as brief as possible so I could make up some time, but if anybody's got any questions, thoughts, concerns. I'm the first person who doesn't get questions. Okay, all right.
Elementary questions just isn't my world, so pardon me for that. The folks who are doing the evaluations that you said, and you had a slide earlier where the local folks, it's not adequate in terms of capacity. Who are those, who employs them? Who hires them? Is that a state level position? Is it a county level position?
It is not, you want to talk to that?
I can if you'd like.
Sure, go ahead, I think.
The LMEs technically hire them. Our office oversees the evaluations and I'll just add, I couldn't agree more, that they're often now there's some good ones out there, but they're often very inadequate. And there are a lot of reasons for that. And we're trying to address that with a quality improvement program and oversight of their reports and giving them feedback and doing some other things beyond the 6 hours of training, which is all they get.
So
Plus 4 every year, but
the LME NCO is the entity that hires the evaluators, and it's not capacity, I'm sure, is an issue, but you're saying it's the quality of the work.
No.
Yes, I'm saying that's a huge problem, is the quality of the product. Now, the LMEs technically are supposed to oversee that quality, but they often don't have experts in forensic psychology and psychiatry and mental health to do that. So we're looking to sort of help them with that process. And there's been other initiatives even before I arrived. I know 2017, 2018, it was introduced it was recommended that the local evaluation system go away and that we have regional centers attached to our 3 hospitals where we have excellent clinicians and evaluators and expand that. But that was rejected. But anyway, we're looking at all other possibilities, but it remains a thorn in our side.
And to answer the question, I think most of the time, these are just independent, they have their own independent workers. They may be, it may be a marriage therapist or somebody who's a counselor, and then they're contracted through the LMEs.
Yeah, they don't do this full time. This is their side gig, and a lot of them don't have the training, yeah.
One thing we tried that's been a little helpful is, because we all have similar issues sometimes, we put together a checklist that has like the 18 statutory requirements of a competency evaluation. The judge can read it real quick and check it, and if it's missing any of the statutory requirements, they don't have to pay the evaluator. And that has really improved the quality of the evals without having to go through some great bureaucracy. Just don't pay them, and then they redo it, and then they get a list of the checklist, and they're gonna make sure that they're hitting it. But the other big thing is, we keep talking about, you don't have to even evaluate a lot of these people. You can try to divert them into treatment, and that will save you the headache of the revolving door. And we'll talk more in a few minutes, but also maybe moving those cases to some kind of involuntary outpatient commitment to make sure that they're getting services.
I don't know if this is the case in the adult world, but in the world of kids, you can't even get them treatment until you have them evaluated. I mean, a lot of times the evaluations for kids are crap too, no offense, but they are. But I don't know if that's what happens in our mental health system for adults too. That you can't skip the evaluation part. You have to get the treatment.
I don't know of any process at this point, and then maybe this is what the goal is, but where somebody comes in, that person that the judge knows, I know your ITP, or I can clearly see I don't need an evaluation. There's nowhere to go from there.
But the thing is, there's other evaluations. I mean, you don't have to do an evaluation for competency. You can do an assessment to figure out what their actual clinical needs are. And then it's cheaper and they're more effective.
And I think we could, but we don't have that on the table right now.
Well, that's what we're gonna talk about too.
I just don't think there's a big educational factor there with, even no disrespect to the judges, even understanding what an IVC is. I mean, I get phone calls, I'm sorry, all the time, you know, I've had them through the years from my district court judge and chief district court judge. What do I need to do IVC? And because I deal with them on a daily basis, you know, I tell them, you know, we'll send them to me or, you know, have the jail come to me or whatever, and I'll do them, but we just usually have to get a detainer from the DA's office once they're done with the evaluation to send them back to the jail. But a lot of them just don't understand the process for the ITPs.
Do you have difficulty with the third prong of IVC petitions when you have instances like this? The not a danger to themselves, not a danger to others, but without intervention would become a danger to themselves?
Anything that I would say to that would be completely anecdotal. And I think that typically, because it's very easy to see, this person's not committing any crimes that are dangerous right now, but they're using heroin, or
Right.
they're just walking, or they're homeless and it's 20 degrees outside and it's a potential danger, but
I often see that people don't use that prong
Right.
as much as they should.
Agreed.
right.
They wait for something to have happened.
Right.
Just from doing 20 to 30 IVCs every day.
Yeah.
And that's a third of what we do.
Tia Gregson.
There's also a hole in the statutory scheme with these people, ITP plus non-restorable. There's no way to convey this information to law enforcement. I have a lady who was a high-level black belt, very dangerous, beat 2 deputies and killed a man with her hands. She took a machete to another man prior to that. Very schizophrenic. She goes, she's non-restorable. She walks away. I don't know where she's at right now. It terrifies me. But she's in the wind, and the hospital could not enter her into DCI. So an officer coming across her is gonna have no idea. She's an extremely dangerous person. And so there needs to be some statutory fixes that these people, not a public database, but law enforcement ought to know that if she is not under someone's care, she is liable to be very dangerous.
Should be some footnote in CJ Leeds or something.
Do you have a red flag system at all in the dispatch?
They just told me they couldn't do anything.
We have a red flag, and so when the dispatcher pulls up, it's usually based on the address, and so if they've been out there before and they know there's mental health, the dispatcher's automatically gonna tell the law enforcement who's going out to that house, hey, be careful, blah, 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 and it really helps.
I think that it probably speaks to, as I say in the trainings that I do in this area, you know, we have this criminal justice system and we have this mental health system, and independently, I hope they work pretty well. But then when you try to force them together, the cogs don't always line up the way they need to, and people wind up falling through and victims wind up falling through. And hopefully discussions like this that we're having are going to help to close those cogs together so that they work more seamlessly. So I think, is it time for a break? Or no, we're gonna keep plugging along?
Roll into the panel next.
Okay. I'm gonna get out of the way then.
All right, we've got a nice little panel table set up so we can stare right at all of you.
Yes.
Here.
I'm gonna do that. Sure. Oh, no, I'm gonna. Take you guys off.
So it's not Germany. Cops, yeah.
And report that. Just watch it with this man. Don't start. Well, in the counties, well, Swipe, Stuttgart.
Must be able to like signal.
Oh, that's true. If you're behind us.
You know, like be throwing stuff at your head. So that's not good.
First time whatever was in 2000. And when the war started cranking up.
Stella, you're moderating, so I'll turn it over to you whenever you're.
Ready now for the panel session. Don't make me bring my English accent out any more than it is. No, oi. I need one of these. There must be like a gavel somewhere in this building.
Sure, we can find one for you.
Okay. Okay, thank you, guys. We're gonna move quickly into this quick panel session. My name's Stella Bailey. I'm the section chief for the Justice Systems Innovation section in the Division of Mental Health, Developmental Disabilities and Substance Use Services. It is not your justice system I'm trying to innovate on. My responsibility is ensuring and finding ways for all of those behavioral health services that DMH provides is providing the right type of service and care for our justice involved individuals, which is how I got involved with this particular piece of work. Referring back to what I alluded to earlier about, you know, community services and ensuring that our treatment services in the community are positioned to really provide the right care for these individuals and how all that works across the system. So I'm joined here today by three colleagues who are working very closely in this system and providing in lots of different parts. So I want to introduce Zeev Dalsheim-Kahane, who's policy advisor for the Governor's Office, and he will be talking about a lot of the roadmap issues and innovations there. Of course, you've met already Dr. Bob Cochran, our State Forensic Director, and we are very pleased to be joined by Dr. Barvin Schwartz, professor and researcher at the Wilson Center at Duke Law. So welcome. Thank you very much for agreeing to be in this panel. I know time is limited, so I'm sitting here to kind of maybe hopefully direct the timing. So if you see me wave, knock, it's time's running short. But I want to go ahead and start with some of the broader work that's happening across our system. So Zeev, if you could first talk a bit about our roadmap. Last year, Governor Cooper released his behavioral health roadmap, put a really strong focus on our justice involved population. So we just wanted you to speak to that.
Yeah, so I'm on a panel of experts here, and also a lot of what I'm going to say you've heard already today, so I'll be pretty brief. But I just want to reiterate, Medicaid expansion has really been a once-in-a-generation opportunity. It's going to provide, once it starts, over $500 million a month and provide insurance to over 600,000 people in the state. These are people who are working multiple jobs, veterans, people in difficult situations. It's going to help keep rural hospitals open. It's going to provide more jobs to North Carolina. But in addition to this $500 million a month, it also comes with a huge signing bonus of $1.6 billion. So with this signing bonus, Governor Cooper, who has been very, very focused on mental health issues, issued a behavioral health roadmap of $1 billion to make sure that North Carolinians are able to access the behavioral health care that they need. And his plan focused on three things: making behavioral health services more available when and where people need them, building strong systems to support people in crisis and people with complex needs, and enabling better health access and outcomes with data and technology. $150 million of his plan was focused on the intersection of behavioral health and justice systems. And I can go more into this breakdown later if you'd like, but some of the focuses were on expanding diversion and reentry programs, which we've talked about, increasing access to jail-based capacity restoration, providing educational resources for judges and other people working in the justice system, and more. And I really feel that this moment was a moment of unity in Raleigh because the General Assembly really agreed with a lot of this roadmap and with a lot of Governor Cooper's plan, and made an $835 million investment in behavioral health in the most recent budget, $700 million of which directly supports the governor's roadmap. And the number that Secretary Kinsley was mentioning a lot this morning, $99 million of that plan goes over 2 years for community-based pre-arrest diversion and deflection programs. So I feel that right now we're really at a special moment in the state for behavioral health and especially for behavioral health for justice-involved populations.
Thank you. Easy. I'm gonna move to topic 2. We're gonna talk about, and Bob, I'd like you to speak. If you could please, because you have been working in the state for your career on exactly these issues. And now as a state forensic director, what do you think the most critical changes are that we need to make just to ensure that our behavioral health and criminal justice systems are achieving the outcomes they've been designed to achieve?
Great question, and I appreciate you giving it to me in advance of today, but I still don't know that I have a fantastic answer, but nonetheless, I think it's easy to say we need more community resources, but that's exactly what we need. Unless we make a huge investment in community resources, we're not gonna be able to expect recidivism to go down, keep these people out, and so I was talking about the hospitals earlier, and you may have seen the slide, we keep people in the hospitals way too long. They're in there too long quite often because we can't get them connected back to the community because there are no resources, or there are limited resources, whether it's housing, mental health, and so on. You had mentioned, Judge Leifman, the outpatient commitment. That's fantastic, but who are you gonna commit them to many times, right? You know, when the providers don't exist or the structure doesn't exist or you don't have someone to monitor it. So it becomes a challenge unless you have those community resources in place. You're not gonna help those in jail. You're not gonna help those in the hospital until it's set up in the community. The second, I guess there's 3 things I thought of when you posed the question. The second is a data collection, which I talked about earlier. You know, we are not a centralized system. We have 100 counties. We've got 3 state hospitals. We've got 6 LMEs. We've got the pilot programs now, a number of courts, right? All with different data sets. Now we have a new electronic medical record in the hospitals, and how many counties now are doing Odyssey, the new court filing system? 5, is it now? Okay. So we have all these different data sets, but they all are related. And it's important that we sort of integrate them as best we can or find ways to share. And again, you know, Emily and I are starting to work on that a little bit. So I think that's a critical part of this whole process is data. I know data is boring in many ways, but if you don't have the data, you can't make the right decision. So, and the third thing would be legislation. We have in North Carolina a unique thing. You know, when I came from the federal system to here, not that I didn't already know about it in North Carolina because I've lived here a while, but we have this oddity, what I thought was an oddity of IVC and ITP being linked together when you don't find that in most places. So I think, and there's some work that we're being done for this, that's being done not by me, but by others that I'm happy to contribute to about decoupling the IVC and ITP process. You know, making that decision about whether someone goes to the hospital or anywhere in the criminal court, and not make this parallel process that we have now because it just complicates things. I mentioned earlier, a lot of people don't meet IVC criteria. They're not a danger to themselves or others, but they go to the hospital anyway. And also in our statute, capacity restoration in particular is barely mentioned. I don't know if many of you have looked at it. You would think there would be this nice little description about what should happen with capacity restoration, where they should go, and how long before the reports need to come back. None of that exists in legislation. That would be the third thing, and I think we really need to focus our attention on.
Great, thank you. And we're moving along quickly, guys. Thank you for that. Marvin, you are an expert in this area. You've done a lot of research in a lot of different places. Who's doing this type of work well? And what are they doing that really makes a difference?
Thanks, and thanks for inviting me. I do want to apologize for not wearing a tie and violating norms, but I've been working remotely so much that I thought it was a big deal to get out of my pajamas. My apologies, but I want to emphasize the point about data systems. North Carolina, if we really want to improve the system and the cross-system linkages in North Carolina, we need to make data sharing more available. A lot of the research we've done in this area is in other states because you can. And there's big barriers here, and if we want to improve the system, we need to, like the data sharing agreement you're talking about would be really important, but there's a lot of areas we could improve. I did want to say something about involuntary outpatient commitment because we've mentioned it so much, or AOT. We did have a pretty good system in North Carolina for involuntary outpatient commitment, which was codified in 1992. So there were some judges that were experimenting with it, and then in the legislature then codified it in 92 as part of the involuntary commitment law. What it does is it's a civil court procedure whereby a judge can order a person to comply with treatment. And we found in a randomized trial in North Carolina done now some years ago that it reduced rehospitalization, reduced arrest, reduced victimization of the person themselves, reduced their violence, improved their quality of life, and reduced days in the hospital significantly. So it cut the length of stay considerably. We did a similar evaluation in New York State, which has the model law for AOT. It's called Kendra's Law. And there we found that it did all the same things and reduced costs, overall costs of the program and hospitalization by 50%. So the average person on AOT, prior to AOT in New York, was costing about $100,000 a year. We saw in the 2 years after AOT, if someone got on AOT, that their costs went down to about $50,000. Now that sounds like a lot of money, but it's half, and there was considerable savings involved. These are pretty ill people, and they they cost the system a lot. So I think that's sort of a model system that we could emulate. The problem in North Carolina, and the reason, in my opinion, the system fell apart was mental health reform. Because prior to mental health reform, counties who ran the area programs were accountable for that system. So if someone came out of, say, the state hospital and went to a county program, like in my case, Durham County, that county program was responsible for that order and maintaining the order and finding and treating the person. Under mental health reform, with privatization and diversification of the program, since they're now private providers, these are more expensive patients. And so if the LME MCO has to contract with someone to take responsibility for that order, and it's just fallen through the cracks. So if we want to make that system work, and it's controversial because there are some people who think it's a violation of people's civil liberties, because you're putting someone under a court order to adhere to treatment when they haven't broken the law. Their crime is recidivism in the mental health system. But we've seen that it does work.
Bless you.
We have seen that it works. It works remarkably well in the states that do it well. I know that sounds like a cop-out, but a lot about involuntary outpatient commitment has to do with implementation. Like we're asked often, does it work? And our answer is it depends, because it's really in the implementation. It's not like a clinical trial where you can say this drug works or doesn't work. It's a complicated community intervention with a lot of moving parts. And so how you implement it and whether you use it long enough. So we found you had to use the order about 6 months or longer for it to be effective. And you had to pick cases of people who had treatable mental illness. So I think that's a thing we could work on. And I think it would help, particularly if we selected cases. Many of the cases now in the system are people who are really doing it just to avoid risk. So if I discharge a patient on outpatient commitment, I've avoided my risk, but it hasn't really helped the person, right? Because there's a lack of follow through. The other thing we could consider, and Steve mentioned this, is New York added to its law that any person with serious mental illness coming out of the justice system, so coming out of prison, had to be evaluated for AOT and then put on the order. So that would be another tool we could have in our tool belt to try to deal with reentry issues of people who are coming out. The one thing, this wasn't what you asked me, but I want to emphasize is we need to be careful that we're not diverting people to nothing. And we have many, many treatment deserts in North Carolina. So, you know, quid pro quo of ordering someone to treatment ought to be, is there appropriate treatment? And we have, you know, many counties that just don't have enough to divert, you know, for diversion. But we can use this, you know, really extraordinary opportunity in the budget and what's happening with the opioid settlement dollars to really make sure there's good treatment around the state and that we're using evidence. Another issue is evidence-based treatment for opioid disorders. We want to make sure that people are getting good treatment. So I think that, you know, there's a lot of opportunities. There's a lot of things we're doing well, and I think there's some things we could tweak a little bit to improve.
I agree. I think there's a lot going on in this state, and there's the fact that we're here today and we have such tremendous support from the governor and from Chief Justice and our secretary specifically on this issue. One thing I wanted to, I'm going off script, sorry guys, but I wanted to talk about something that we touched on a little bit with the debate around the jail-based capacity restoration, and touch a little bit over on what's happening over in Onslow County with crisis. And that's just talking directly to our beds and our wait list in the state hospital. So what we have, and this is why I have a particular interest in the state hospital bit, although I sit in much more of a community mental health setting. So we have wait lists at our state forensic hospitals. You have people waiting in beds in all of our other hospitals. And that means our clinicians in those hospitals are making risk assessments, and there's other people that need those beds. So the cascade effect is that you're more likely to see more people reaching a crisis point in the community or being exposed to situations which are causing trauma, which may then there's someone down the road where they need more behavioral health help. So as much as we're putting in to our system, we have mobile crisis in every single county. We have 36 counties covered by dedicated diversion and reentry services. We have a statewide work group that Zebe and I are working on to improve the deflection and diversion. We are still seeing a huge rise in the need of these services. So we have a tremendous opportunity to take both of those issues and think about what's right for our citizens, our residents, which is where the jail-based capacity came from. It's like, we know it's not ideal, but what also is not ideal is for these individuals to stay in a jail when they haven't been convicted, or to stay in jail until they go to a state hospital where those beds spaces are desperately needed. So this, with all of those challenges and experiences that we have and this funding, I think I'm really looking forward to the conversation that we're gonna have next. But I also want to open up after that segue to this panel too. I mean, is there anything else that you want to mention about how our system is working, what we need to look at, and how we move forward?
One thing that was emphasized earlier in Secretary Hensley's comments is about Medicaid. And I mentioned it a little bit before, but because in Medicaid regs, the inmate exclusion policy means that once you've been in jail, I think for 30 days, it's either your Medicaid suspended or revoked. So we need to do, if we want folks to have purchasing power when they leave, you know, and recall that 2/3 of people in jail are just awaiting trial. They haven't been convicted, but while they're sitting in jail, they're losing their Medicaid, particularly for severely mentally ill. So I think that's really ought to be an important priority, and I know it is. You're applying for a Medicaid waiver.
And one other thing on that, Marvin.
Yeah.
Does North Carolina have a law that allows for suspension versus termination? You'd rather be suspended than terminated.
Yeah.
Because you can get turned back on within 30 days. If you're terminated, you have to start all over.
It is suspended.
Okay.
Yeah, so I think it's just critically important that we do reach into do case finding, get people on Medicaid, and relieve the counties of some of the expenses, for jail-based treatment. And so I think it's great that that's one of our priorities of the division two.
When you asked the question, a worry came up because, I continue to see, as many have seen, that we have a workforce problem. We can have a lot of money, we can have a lot of great ideas. If you don't have the people to do it on the ground, then it's gonna be a struggle, to say the least. I was reading a Duquesne University study where there's gonna be, in the next 10 years, even 120,000 fewer physicians in the country. And then on television, this isn't don't quote me where I got this, but it was on whatever program I was watching, they highlighted that 70,000 qualified nurses did not get into a program because there weren't enough preceptors, instructors, and professors to take care of them, to train them and to monitor them. So all these potential nurses, and nurses are a huge problem in our hospitals, the biggest problem probably. Even when the people are interested, we can't get them into the workforce, or it's a struggle too. So that's part of my worry. So we need to be thinking about workforce issues. And I know DHHS has been, and there's some initiatives there that I'm less familiar with, but I just want to mention that.
And I'll just say, I'm just very excited that these kind of conversations are happening. What we're having today is happening. I think it's really important to message to people across the state that, for folks with substance use disorder or serious mental illness, it's important that they get treatment rather than incarceration, and that sort of shifting the focus will help. The system's really overloaded, and shifting the focus will help those people, but it'll also help law enforcement, judges, prosecutors. It's a win-win across the system.
Thank you very much. And I am very conscious of time. We are close, we've gone over our 2:15 start for the big discussion. Are there any last comments from you or any questions that anyone else would like to put forward?
And we've got time. I don't want to cut them short. So anybody has any questions, feel free.
Can I ask our consultants a question? One of the things that didn't come up in the capacity restoration conversation is, I wonder if part of the dynamic is that judges get impatient with the wait on state hospitals and use ITP as a way to jump the key to get a state hospital bed.
I don't know, yes and no. The no part is they don't have any, in our state, at least in my circuit, we're so big, we just have criminal court judges. So they don't have an option to send, that the civil case isn't coming in front of them, so they don't have that option. So, but what I do think happens with ITP is judges misuse it because there are no services in the community at all. And forget civil, it's just they can't get the person help, and they don't want to just release people to the street because they're afraid something terrible is going to happen. So they do misuse the ITP system because they think it'll get them some treatment. It's not a treatment system. We try to explain that